So let's talk about independent films for a minute. Independent films are kind of a whole different animal, aren't they, Evan? I mean, they just...
Yes. With independent films, you have independent producers who, and it's probably worth talking about, that the valuation of music and where it comes in the process. For independent film producers, in most cases, for film, the music will come at the end. For independent film producers who are on a shoestring budget, by the time they get to the composing aspect, they've budgeted very little money, and so they tend to be more creative in the deals they make. So you can, and we could talk about it, you can do a license, it depends on the fee that you're offering the composer. A typical scenario would be that the producer will inform its attorney for the production how much money they have in the budget, and either the attorney or the producer will make an offer to the composer or its agent or manager. Sometimes foolishly, they leave out the grant of rights from those discussions. So sometimes we as the lawyers have to clean that up.
When you say license, so in this case, the production company or the independent producer would get an exclusive license for that music for a period of time, or would it be in perpetuity, or how would that work?
Yeah, it would be in perpetuity. The idea is the composer says, look, you want to pay me a package fee of $15,000, which is extremely low. It includes all of my recording costs as well as my creative fee. I'm not going to give you copyright ownership of my music, but I will give you the rights you need to distribute it in the film. So that would take the form of a grant of a license, a synchronization and master license. Typically, it would be perpetual, worldwide, all media.
And in that case, the composer would be able to collect the performing rights on both the writer's share and what we call the publisher's share, although Phil will tell me there is no such thing as a publisher's share, right? It's industry norm. But so he would be able to collect 100% of the performing rights.
Correct. In these contracts, you'll see the composer usually wants an express provision that says, for the avoidance of doubt, the composer shall be entitled to collect 100% of the so-called writer's share public performance income and 100% of the publisher's share public performance income. And of course, they'll own the copyright, so they can, after a holdback period, which we can talk about, they can exploit the music in other ways. They themselves can reproduce records and offer downloads. They themselves can license it for another use. As you said, in that case, they would not be infringing a copyright. Typically, you'll see a holdback period of somewhere between 3 and 5 years.
Sure.
The producers and their distributor would be loath to see their musical score being reproduced in a Honda commercial on the heels of 3,000 screen
Sure,
release.
and I suppose it would depend on the role that the music has in the film. I mean, if the film is about a songwriter writing a song, that song has got to be. I mean, that's got to be. You'd hate to see that song show up somewhere else.
Absolutely.
In another place. Steve, any other comments on independent film deals? What's the strangest independent film deal you ever saw for a composer?
The strangest deal is I had a composer who was a BMI composer, and the film company was ignorant as to how ASCAP and BMI worked. And so when the client asked what their BMI publishing company was so he could do the music cue sheet, they said, we don't have one. Can you put it down as ASCAP? And of course, BMI writers can't write for ASCAP companies. So what I have found is that somewhere in producer school, they were told that they have to own the music, which is not true. The kind of license Evan was describing, a very broadly worded license giving them all the rights, not only in the film, but in sequels, prequels, in and out of context trailers, anything having to do with the film, gives them all the rights they need. The problem that the independent film companies have with that is that sometimes the distributor will want the music rights. And so sometimes you can, if you're representing the composer, put in something into the agreement that I, the composer, will own the music. However, if a production company or distribution company wishes to purchase the music, we will negotiate in good faith for a purchase of the music copyright, so that now I transfer the copyright to the film company or their distributor for an additional fee.
So I think this is especially important because overseas, theatrical income is a big part of film music income, right? I mean, and let's talk a little bit about this. Let's talk about, you want to talk about Alden Rochelle a little bit and why American composers don't get performing rights for music that's in films that are in theaters?
Well, Alden Rochelle is a case that goes back to the 1940s when the movie studios and the theater owners were owned by the same parties. And so antitrust violations were accused against those parties. And the Supreme Court held that because of those antitrust considerations, movie theaters in the U.S. would not be obligated to obtain public performing rights licenses and, of course, not pay public performing rights fees. So for theatrical exhibition in the U.S., there is no money generated through ASCAP, BMI, or CSAC for performing rights. But as Doug clearly mentioned, overseas the rules are different, and theatrical performances for theaters outside the U.S. can be substantial. The other countries have different laws. The Alden Rochelle case was based just on U.S. law and only applies to the U.S. And so overseas theatrical performances can be substantial, assuming the film has some degree of success.
Very fortunate, I think, that the foreign PROs haven't taken the same position that, for instance, they've taken on the copyright in a sound recording, because in the case of a copyright in the sound recording, American copyright owners of sound recordings aren't getting paid for performances in Europe because we don't collect for them over here in terrestrial broadcasting.
And that's for analog radio and for television.
That's right. But so I'm glad that for the sake of the television and film composers, I'm delighted they haven't taken the same position as far as that's concerned. They're paying us even though their composers are not earning anything over here. And what do you think the chances are that? I mean, it just seems unfair on its face. Can I say that? It just seems unreasonable to me that one particular group, one particular industry is excluded from paying performing rights.
I agree that it's unreasonable, but typically the agreements that we see, both for composers and for outside songs being licensed into a film, indicate that there is a grant of performing rights for domestic theatrical exhibition as part of that grant. So the composer in their agreement or a third-party publisher licensing a song into the film acknowledges that that exists. And to be honest, I think that's unlikely to change. I mean, we've got 70 years of precedent in the Supreme Court. Getting them to change it would be monumental.
But that's why sync money for, to use a hit song in a film is considerably. Those are big numbers typically, because what you're paying for is the synchronization right and the performing right for all domestic uses.
Well, it's not just
in
that.
Theatrical.
Typically, sync licenses are done as a buyout, so there's no royalties for DVD sales or downloads either. So the film company is buying out all of those rights, not just for use in the film in theaters and television, but all copies of the film made in aftermarket for digital CDs, DVDs, or downloads. So those rights are being entirely bought out, and I've seen fees upwards of $1 million for big hit songs.
Wow. I should be a songwriter.
Let's go write something, Doug. Come on.
So, okay, so what's the future look like in terms of how films are going to be distributed and viewed, and how is that going to impact composers going forward? Putting aside the question of ASCAP and BMI for the moment, are there patterns in the distribution of films that you think will impact composers, and what should composers be thinking about as they, as a deal memo comes across their desk?
Well, certainly we have, content now being, created and distributed and now created by new networks, if you will, like Netflix, Hulu, Amazon, and perhaps that's what you're alluding to. The one thing that comes to mind, although you said putting aside ASCAP, BMI, and CSAC, is to ensure that, they have valid and subsisting public performance licenses so that when it's aired on their channel, their subscription service, that the same type of performance income you'd earn if it was a broadcast network you earn.
Right.
Other than that, I'm not sure much has to be different. If Netflix is commissioning you to, score House of Cards, they likely will want work for hire, like we discussed. They likely will not have a problem giving you standard composer royalties, as Steve alluded to, 50% mechanicals, your writer share performance income, third-party synchronization. So to me, a lot of it boils down to the performance side.